Welcome, everyone. This is Bert Coley, Director of Compliance at Enterprise Recovery Systems in Woodridge, Illinois. Today, we will discuss the New York Regulations Part 2. Earlier, a couple of months ago, I believe, we did send that communication which outlined the March requirements for the New York State regulations for debt collections. And so we have already entered into that phase of compliance with the New York regulation. Today we will discuss phase 2 with a August 30th deadline for compliance to the requirement. The agenda today includes the fact that the regulation is effective August 30th of 2015. The regulation impacts charged-off account requirements. There is a new process for debt collections in the state of New York called substantiation, and we will discuss substantiation requirements in New York State's dispute process. And then lastly, we will discuss some business decisions that will need to be made. Starting off, again, effective August 30th, we will need to be in compliance with the New York State regulations for debt collections. It does impact charge-off accounts. There's a specific requirement that the debt collector must provide specific additional information within 5 days after the initial communication. And that information is slightly different than what we currently provide in our debt validation letters. Secondly, if a consumer disputes a debt, we must provide instructions regarding substantiation to the consumer within 21 days. And one thing I want to point out in the presentation is that we have highlighted the text of the New York State regulation or their frequently asked questions section and highlighted that in blue. So whenever you see blue throughout this presentation, you can take that as a direct quote from New York State. The first thing that I want to discuss here is the definition of charge-off accounts, because that's what's impacted by the regulation phase 2. Charge-off accounts means the accounting action taken by an original creditor to remove a debt obligation from its financial statements by treating it as a loss or expense. And this is the definition by New York State. And as we would always suggest, speak to your compliance people or your legal counsel regarding that definition and how it impacts you. Within 5 days after the initial communication with a consumer in connection with the collection of any charged-off debt, a debt collector shall, unless the following information is contained in the initial communication or the consumer has paid the debt, provide the consumer clear and conspicuous written notification of the following: the name of the original creditor, an itemized accounting of the debt, including the total amount due at charge-off, the total interest accrued since charge-off, the total amount of non-interest charges or fees accrued since charge-off, and the total amount of payments made since charge-off. You will notice here that there are new requirements for this initial communication that make it different from the typical debt validation letter that we have sent. But these are the very specific requirements outlined by the state of New York. And what it means is that this is new information that has to be provided by the client and programmed by the debt collector to provide in its communications to consumers and its initial communication. I also there's another quote from the state of New York, and I'll read it verbatim. Substantiation requirements. Substantiation. If a consumer disputes orally or in writing the validity of a charged-off debt or the right of the debt collector to collect a charged-off debt, the debt collector must inform the consumer that the consumer may request substantiation of the debt. Substantiation requires a debt collector to provide additional information to a consumer about how to receive substantiation of a debt if the consumer disputes the debt, either orally or in writing. The requirements for substantiation of the debt include more specific information than is required for verification under FDCPA. Thus, debt collectors must work with clients to retain the required information. So what this is saying to us is that the dispute requirements that we have had in place for a number of years under FDCPA no longer meet the requirement for dispute/substantiation for New York State. And we will go into a little more detail regarding that. Substantiation requirements. Just to outline the substantiation requirements, we have to provide instructions to the consumer as to how to file a substantiation or how to request substantiation from the debt collector. Written dispute. If we receive a written dispute, we must mail instructions to the consumer within 21 days. And we must mail instructions regarding how to request a substantiation, which again is increased documentation that must be provided to the consumer to validate the debt. Verbal dispute. Explain instructions verbally and mail instructions within 14 days. Response requirements. Clients will need to supply the required documentation and allow affiliates time to meet the 60-day time frame to provide the documents to the consumer. So again, I will repeat, if we receive a written dispute, we must mail instructions to the consumer on how to send a substantiation request to the debt collector. If we receive a verbal dispute, we must explain to them verbally how to send us a substantiation request and mail those instructions within 14 days. And again, we will, once we have a substantiation request, we will have 60 days to provide that documentation to the consumer. I will read again directly from the New York State regulation. If the consumer disputes the debt orally, the debt collector must make reasonable efforts to inform the consumer in the conversation in which the dispute was communicated how the consumer can make a written request for substantiation of the debt in writing, and within 14 days of the consumer disputing the debt, provide the consumer clear and conspicuous written instructions on how to request substantiation of the debt. Or if the consumer disputes the debt in writing within 21 days of the debt collector receiving that writing, the debt collector must provide the consumer clear and conspicuous written instructions on how to request substantiation of the debt. Moving on, a little bit more information about substantiation. Substantiation requires documentation be provided to the consumer. That documentation could be a copy of the judgment against the consumer, if a judgment has been filed, obviously, or all of the following: a signed contract or application. If there is no contract or application, then we would have to provide the last statement showing the purchase, payment, or transfer of the debt, and a charge-off statement that was provided to the consumer, and a statement of the chain of title of the debt, and any records of a prior settlement agreement with the consumer. Now, what this means to all of us, it means that if we receive a substantiation request, cannot simply close and return the account. It does not satisfy the New York State regulation for a substantiation inquiry. We will have to send a letter of instruction on how to satisfy a substantiation request if the consumer makes that request. It also means that if clients do not provide the documentation to the debt collector within a 60-day time frame, that ERS, the debt collector, will be in violation of the New York State Department of Financial Services, DFS regulations. And with that would be a civil monetary penalty of up to $5,000 for each offense. Moving on, more information regarding substantiation. The debt collector, ERS, must retain the consumer's request for substantiation and all documents that were provided in response until the debt is either sold, transferred, or discharged. If a consumer requests substantiation of a debt, and I'm reading directly from the reg here, the debt collector must retain the following documentation until the debt is discharged, sold, or transferred. Evidence of the consumer's request for substantiation and all documents the debt collector provided in response to the request. And this simply means that all the documents must be retained for consumer requests, for auditors, and examinations. Okay, I will read again from the reg. In lieu of providing information required in 23 NYCRR 1.4c, to substantiate a debt, can a debt collector issue satisfaction of the debt in order to avoid being in violation of the regulation? And the response is yes. Failure to provide the required information within 60 days of the receipt of the request for substantiation is a violation of the rule enforceable by the department. However, if a debt collector extinguishes the debt within the 60-day time frame and there is no longer a debt for which to provide substantiation, the debt collector would not be in violation of the rule if substantiation were not provided within 60 days. See NYDFS FAQ. And this is a quote directly from the New York State FAQ regarding substantiation and the New York regulation. And what this means, it was quite a mouthful, I understand. If the creditor is unable to provide the debt collector, ERS, with the substantiation documentation, and that is all the materials that we listed earlier, then the creditor may forgive / extinguish the debt in lieu of providing the required information. And in fact, this is the only way for ERS to avoid the fine if the documentation cannot be provided. Again, we cannot close and return that account. There is no other action for ERS to take other than extinguishing the debt or providing the documentation to the consumer. And I will quote again from the New York State FAQ. If a debt collector, ERS, cannot provide substantiation of a debt and is not the owner of a debt and therefore cannot forgive the debt, can the debt collector return the debt to the creditor? A debt collector cannot satisfy the obligation to provide substantiation by returning the debt to the creditor. Debt collectors who do not own the debt and therefore cannot extinguish the debt can avoid potential violations by ensuring that the debt can be substantiated before commencing collections or receiving assurance from the creditor that the debt can be extinguished if substantiation is requested but cannot be provided to the consumer, that is. See NYDFS FAQ. What this means, essentially, ERS will work with each of our clients to identify whether or not they have charge-off debt that is placed with ERS. And we will need to validate the capacity of the client to provide said documentation, as that was quoted earlier. For example, provide the required documentation or be willing to forgive the debt if that cannot be provided. Quoting from the FAQ again, can a third-party debt collector have the original creditor provide documents responding to a request for substantiation of a debt? Yes, a debt collector may have the original creditor provide the required information. However, the debt collector who received the request is still responsible for ensuring that the information is provided within the time frame required by the rule. See NYDFS. Okay. What this means is, if the client elects to send a substantiation to the consumer directly, the client will need to notify ERS that that documentation was sent, because ERS is ultimately responsible to ensure that that documentation is placed in the hands of the consumer, or that the debt is extinguished in order to meet the requirement of the New York State regulation. I hope that we have put some clarity to the material that's been presented. And I hope that everyone understands exactly what the requirement is. So I'll close the presentation with a couple of thoughts here. Firstly, that we have provided some resources for you to review the regulation directly. And the addresses for, well, the web addresses for the frequently asked questions and the actual proposed, well, the actual New York State debt collection regulation are included on the last page of the presentation. And our next communication to you, we will include that information as well. We are anxiously anticipating questions and look forward to them. We will review them in our compliance department with our internal counsel as well. You can contact me directly through my email address. Again, my name is Bert Coley. My email address is bcoley@ersinc.com. That information, as well as the information of other contacts, will be included in our next email communication. One more thing that will be included in our next email communication is a request for an attestation. As you can see, this is quite a requiring regulation, and with significant fines if we're unable to meet the requirements of the regulation. So we would like to ensure, to protect ourselves as well as the clients, that you can and are willing to provide the documentation. We are affording you an attestation to simply state that to us, that you do place charge-off debt with us, that you are able to provide the required information to us in a timely fashion, which that is 60 days, and that if you have placed accounts with us with the thought that you would be able to provide the documentation, and for some reason that documentation cannot be retrieved or provided to ERS, that you would allow us to extinguish the debt. And again, there's a 60-day time frame from the consumer placing the substantiation request to that information making it back to the borrower's hands. That will be attached to the email communication. And again, please feel free to contact us with any questions or concerns. And lastly, we do encourage you to consult your internal compliance department and or your legal counsel. So thank you very much today. Thank you.